Hi everyone, it's Mark and Korshik from Chartergate Legal Services with another instalment of our Legal Insight series focusing on the Employment Rights Act. In this video, we're going to be looking at the changes to fire and rehire rules. Korshik, most people won't have heard of fire and rehire until the P&O scandal from a few years back, which made the newspapers, made the TV, and was, brought the concept of fire and rehire to the mainstream.
Yeah.
So what does it mean and what's changing?
Well, Mark, that's a really interesting example that you flag up. Of course, we come across it in our practice all the time, but the P&O ferry incident, and call it that, was really capture the public imagination there. So what we had there was staff members working for a company, and when the company decided that those staff members were too expensive, they terminated their contracts and employed other people on cheaper contracts, essentially, on cheaper levels of pay, lower levels of pay. Now, at the time, it caused a bit of a stink, and obviously it was all over the news and in public literature, but it turned out it was, broadly speaking, okay for the company to do. So fire and rehire essentially involves terminating an employee's contract and rehiring them on terms that are significantly less attractive or beneficial than the terms that they originally had. So at the moment, there's two really lanes, let me put it that way, that we potentially have. One lane is for those that have less than the requisite service.
Okay.
Another lane is for those that have above the requisite service.
And this is the requisite service to claim unfair dismissal?
To claim unfair dismissal. For those that have less than the requisite service, it's a pretty straightforward process, really. It's a question of terminating the contract, re-employing, re-offering a new contract with the far less attractive terms in that contract. So, for example, you could have a member of staff who's on £50,000 a year, you terminate the contract and you re-employ on a contract which has a salary of £25,000 a year.
Okay.
Perfectly lawful at the moment.
And the individual either accepts that or they're out of work?
Either accepts that or they're out of work.
Okay.
Absolutely. So for that second lane, a process would need to be followed. And that process would often involve a process of consultation, balancing the competing requirements of the employer against those of the employee. But ultimately, at the end of that consultation process, if the employer decided that they still needed to go down that route, and they could provide some justification for that route, then they could still terminate the contract and re-engage on a new contract.
So that's the law as it stands?
That's the law as it stands, and it's called a dismissal and re-engagement for some other substantial reason.
Okay.
Yes.
Colloquially known as fire and rehire?
Colloquially known as fire and rehire.
Okay, so what's changing? What's the Employment Rights Act doing?
So the Employment Rights Act is going to essentially outlaw that altogether.
Okay.
And shift the burden entirely onto the employer. So what the Employment Rights Act is going to introduce is this concept of restricted terms, or restricted variations, I should say.
Okay.
And what that means is there'll be a number of core terms. Now, they're the obvious ones that you'd be familiar with. Terms relating to leave, terms relating to pay, terms relating to pensions, terms relating to hours. And those terms will essentially have a bubble of protection around them.
Right.
And what does that mean? Well, it means that it then becomes very, very difficult to change those terms. An employer will have to show that changing those terms for that employee, or even for a group of employees, is necessary to their financial viability, and that there's no lesser way that they can avoid or mitigate the impact to their financial viability, and that it's the only reasonable thing they can do in the circumstances.
Okay, so if I understand what you're saying correctly is, so essentially what we're saying is you can still try to vary those terms. You can still negotiate to vary those terms. But if you want to dismiss and offer new terms because the business is struggling, the burden of proof, the bar they have to clear is significantly higher. I appreciate you've gone through the legal test, but what we're really saying is if there is no other option and the employer can prove that.
Essentially, yes, absolutely. Okay. And to make matters worse, it also now becomes an automatic unfair dismissal complaint as well. So what difference does that make? Well, at the moment, there's a cap on the compensatory award that can be awarded for ordinary unfair dismissal complaints. Automatic unfair dismissal complaints, there is no cap. So potentially, if an employer goes down that route, not only will they have that higher bar to clear, and they will have to evidence it as well. So I think commercially as well, how that might impact a potential employer having to go to an employment tribunal and put what could be quite commercially sensitive data into a public forum. But if they still can't then persuade a tribunal, they then have the risk of having the compensatory cap on unfair dismissal awards essentially taken away and removed.
Okay. So what should employers do because, look, fire and rehire, like I said, it came about because of, people knew about it because of the P&O scandal, and that was a particularly harsh operating of fire and rehire, but businesses do hit difficulties, especially in the current economic climate. So what can they do to protect themselves from these changes, and how should they go about scenarios where they find themselves in a position where they might need to negotiate with employees changes?
Well, the immediate solution is to do it before January 2027.
Okay.
So at the moment, legislation is not in place, so there is a window whereby employers can work under the existing legislation.
Okay.
Secondly, if we're talking about what to do after the implementation of this legislation, well, in my experience here at Chartergates, we tend to find this does come up, and our advice tends to be along the lines of, well, try and talk to your staff members, negotiate an agreement, because if they do agree with you, that is better for everybody, minimises any potential risk of claims. Employees will often be happier having been consulted. It works better, both industrially, from a industrial relations perspective, and legally as well.
It's better practically as well, because it means you get to keep the staff that that can do the job, rather than going for a cheaper option that maybe you have to train, maybe they don't work out. So it kind of talking, negotiating works for everyone, I suppose.
Absolutely. The issue is about imposition of new terms or dismissing a member of staff when they don't agree.
Okay.
But if they do agree, and they do agree in writing, then that works better for everyone. It's happy days for everyone.
Okay. Thanks, Kaushik. If anyone's got any queries with regards to the new fire and rehire rules or the Employment Rights Act in general, we'd be happy to help. So just get in touch. Thanks.